Hello students, I am Rahul Sharad Joshi, Assistant Professor at the Department of Commerce, the Bhopal School of Social Sciences. The topic I have chosen for today is Memorandum and Article of Association. To start with, Memorandum is defined under Section 2, Clause 56 of the Companies Act 2013. When we go for the definition of Memorandum, the definition is a bit technical in nature and doesn't say much about what Memorandum exactly is. To put it in very simple language, Memorandum of Association is the charter of the company. The constitution and scope of the power of the company is defined under the Memorandum of Association, and also its relationship with the outside world is defined in Memorandum of Association. Memorandum of Association also contains the objects for which the company is formed, and all the shareholders who are dealing with the company, they are supposed to know the contents of the memorandum. Memorandum of Association is a public document, and every person who is entering into a contract with the company should have the knowledge of the conditions which are contained in the Memorandum of Association. Shareholders should also be aware for which purpose their money is going to be used, and it is clearly mentioned in the Memorandum of Association that what kind of activities a company is going to take by taking the money from shareholders. Now, there are certain contents of Memorandum of Association. When we talk about the contents, they are mentioned in Table A, Table B, Table C, Table D and Table E. Now, Table A talks about the Memorandum of Association of a company which is limited by shares. Table B talks about a company which is limited by guarantee and not having a share capital. Table C talks about a company limited by guarantee and having a share capital. Table D talks about a company of an unlimited company, and Table E is for an unlimited company having a share capital. These are all the contents of memorandum. Now, we come to the clauses which are under the memorandum. We have 6 clauses: name clause, registered office clause, we have object clause, liability clause, capital clause and the association clause. Now, let us discuss all these clauses in details. We start with the name clause. Under name clause, it clearly says that in case of a public company, the name of the company should end with the word limited, and in case of a private limited company, the name of the company should end with the words private limited. This name clause is not applicable in case of Section 8 companies. Now, what is a Section 8 company? Section 8 companies are those companies which are not for profit purposes. In case of Section 8 company, the name will be ending with foundation, forum, association, federation, chambers. These are all the words of which the names are ended in case of a Section 8 company. And now, MCA notification dated June 2015 has clearly said in case of a government company, the name of a government company shall end with the words limited, and in case of a one person company, the name shall end with the word one person. Now, let us come to the second one, that is the registered office clause. In case of the registered office clause, the entire address need not be mentioned. We can only give the name of the state where the registered office shall be there, and every company must have its registered office within 30 days from the date of its incorporation, and the registered office is a place where all the records are kept by the company. Coming to the object clause, this is one of the most important clause. In the object clause, company incorporates what object it is going to fulfill, right. The main thing about the object clause is it should not be against the law. The object for which the company is formed should not be against the provisions of the Companies Act, as well as the object for which the company is formed should not be against the public policy. Now, coming to the liability clause, in case of a company which is limited by shares, the liability clause shall very clearly indicate the liability of the members is limited only to the amount which is unpaid on their shares. In case of a company limited by guarantee, the liability of the members will only arise in case of a company going under winding up. In case of the capital clause will clearly mention the authorized capital with which the company is registered, and a company which is not having a share capital need not have this clause. Now, the last one is the association clause. Under the association clause, it is very clearly mentioned that every subscriber to the memorandum shall take at least one share and shall write against his name the number of shares taken by him. These are all the compulsory clauses of Memorandum of Association. Now, something general about the Memorandum of Association is the memorandum must be printed, it must be divided into paragraphs, and it should be numbered consecutively. And in case of a public limited company, it has to be minimum signed by 7 people. In case of a private limited company, it has to be minimum signed by 2 people, and in case of OPC, that is 1 person company, at least by 1 person. Now, we come to the Article of Association. Now, Article of Association of a company are its bylaws or rules and regulations that govern the management and the internal affairs of the company. So, what article of association tells us is, article of association tells us with the rights of the members of the company, and the articles are subordinate to the memorandum of association. Then what are the content of article of association? These are the contents of article of association: adoption of preliminary contracts, number and value of shares, issue of preference shares, allotment of shares, calls on shares, lien on shares, and transfer and transmission of shares. Rules regarding all these points are mentioned in article of association, as articles of association deal with the internal rules and regulations of the company. Now we come to the difference between memorandum and article of association. The first point is relationship. Memorandum of association defines the relationship of the company with the outside world, whereas in case the article defines the relationship between the company and its members. Coming to the alteration, memorandum of association can be altered only under certain circumstances, whereas articles can be altered simply by passing a special resolution. Then we come to the third point, that is objectives. Memorandum of association defines and limits the objectives of the company, whereas the article of association lays down the rules and regulations for the internal management of the company. Talking about ultra virus, the act done by the company which are beyond the scope of memorandum are ultra virus and cannot be ratified, whereas in case of articles, any act which is ultra virus the articles, it can be ratified by a special resolution, provided they are not beyond the provisions of memorandum. This is all about memorandum and articles of association. Thank you students, have a happy learning.